Hi, hello, namaste, Ram Ram. I am K. Lachiram. Are all land dispute cases fall under civil case? Are they not fall under criminal cases? Then what about cheating, forgery, criminal breach of trust? A complaint filed under section 200 of CRPC is to be dismissed under which section? Is it under 203 of CRPC, or is it under 203 of IPC, or is it under section 230 of CRPC? Which one is correct? Moreover, can an accused set ex parte in criminal offences? Which provisions are allowing to set accused ex parte? And what is the section in CRPC? If anybody knows, kindly comment in my comment box. Now let's go into our main video. Review the judgment of Honorable First Additional and Sessions Court Kamareddy. The flaws, lacunas and irregularities delivered by the Honorable Judge Justice Sri Lal Singh Srinivas Nayak. The brief fact of the appeal is there was a 6 acres 5 guntas agricultural land was in the name of my father. In that 1 acre 21 guntas was ancestral property. 4 acre 24 guntas are self-acquired by my father, who died on 1/5/2009. Thereafter, that land was mutated, or we can say transferred, in my mother's name, Srimati K. Jamunabai, in the year 2012. My mother also died on 2nd March 2016. Thereafter, that land was transferred to a non-legal heir, who is our brother's wife, Srimati K. Mirabai, in 2079. In this regard, the case was filed in trial court at Banswada. The Honorable Trial Court dismissed the complaint under section 203 of CRPC. That led me to file an appeal in the First Additional Sessions Court at Kamareddy. That was heard by Judge Sri Lal Singh Srinivas Nayak ji. Now, going into the judgment, para 1. The criminal appeal is filed by the appellant de facto complainant, aggrieved by the order passed by the learned judicial magistrate of first class Banswada, dated 31/7/2023, in CFR number 274 of 2023. Here, the interesting thing is, any judgment or any order is delivered based upon the case number. This is the regular practice of courts of law. Here my case was heard with CFR number. What is that CFR number? I do not know. If anybody knows, any advocates or lawyers knows, it is up to them. But unfortunately, trial court judge Sri K. Sudhakar ji, without considering the statements of complainant, witness, documental proof provided to the court, leaving all these facts and evidences without taking cognizance, and this case was heard by trial court judge Sri K. Sudhakar ji for a period of more than 1 year. It was took 1 year to the honorable judge to decide whether the case is a cognizable offences or not. After 1 year, dismissed the case under section 203 of CRPC. First Additional Sessions Judge Judgment Para 2. What says? Notice to the respondents number 1 to 7 served through RPAD but they failed to appear before this court. Hence, service held sufficient and they set ex parte. This is basically a criminal appeal. In criminal, accused cannot be set ex parte in any circumstances. That law saying, I am not saying. But here, Honorable Judge Sri Lal Singh Srinivas Nayak ji set the accused ex parte at the cost of court fee which was taken from me, and court was sent notices twice to the accused, not once, twice. Now the provisions of laws are saying when accused is not present before the court, it is a contempt committed by the accused number 1 to 7. It is a great insult to our Honorable Judge Sri Lal Singh Srinivas Nayak ji and of course Court of Law too. The Honorable Judge Justice Sri Lal Singh Srinivas Nayak ji would have initiated contempt proceedings against these accused number 1 to 7 as per the provisions under section 174 of IPC. But Honorable Judge not exercise the power empowered with. What it signals? Why it has happened? Is there any alien powers behind this? Straight away, I'm going to the para 8, 9 and 10 which are the crucial paras of this judgment. Para number 8. Now the point that arises for consideration is whether the order of the trial court passed in CFR number 274/2023 dated 31/7/2023 is sustainable in fact and law. So, whether there are any justifiable grounds to interfere with the trial court order. Then para 9A. The petitioner/de facto complainant vehemently contended that the trial court not properly appreciated the facts and not taken the cognizance against the accused number 1 to 7 under section. There are overall all sections. I'll simply read for your information. Section 23, 24, 34, 120A, 405, 420, /415, 468, 471 and 48 and 499, 166 and 167. These are the sections of IPC I have alleged on accused number 1 to 7. It varies from accused to accused. That much detail I am not elaborating over here. In para 9B, the Honorable Judge says, on careful perusal of the entire material on record, there is no dispute that the appellant/petitioner and accused number 2 are own brothers and they born through Sri K. Ramulu and Srimati K. Jamunabai. Further, there is a cogent evidence available on record that the Ramulu was acquired the land to an extent of 6 acre 5 gunta in survey number 190/1 and 190/2. This is a false observation of Honorable Judge Sri Lal Singh Srinivas Nayak ji. Why? Because as I said, there was a 1 acre 21 guntas was ancestral property, 4 acre 24 guntas was my father acquired. But here total judge is saying 6 acre 5 guntas were acquired by my father. So this is how the judicial mind is working in our Telangana state. Para 9C. Now the core question is whether the trial court followed the provisions as contemplated under section 200 and 203 of Code of Criminal Procedure before dismissal of the complaint. Let us discuss those provisions as follows. This is judge saying, I am not saying. So section 200 of the Code of Criminal Procedure is read as so on. This is a very procedure that elaborated by the Honorable Judge. Para 9D. It says, on careful perusal of entire material on record, one thing very much crystal clearly appears that the learned judicial magistrate of first class Banswara stringently followed the procedure laid down under section 200 and 203 CRPC while considering and dismissal of the complaint filed by the petitioner herein. Further, the learned judicial first class magistrate Banswara given a cogent reason in para number 36 of the order after examination of the complainant and witnesses and come to the conclusion that there is no sufficient grounds for proceeding with the complaint against the proposed accused person. As such, the complaint is dismissed under section 203 of IPC. This section 203 of IPC was nowhere mentioned in the trial court's order. It was the observation and statement of our Honorable Justice Sri Lal Singh Srinivas Nayak ji. Actually, trial court dismissed my case under section 203 of CRPC. But here Justice Lal Singh Srinivas Nayak ji is saying under section 203 of IPC. What 203 IPC is saying? Now I'll read for you. Giving false information regarding an offense committed. This is the provision of law. And if anybody gives false information under this section, they shall be punished with imprisonment of either description for a term which may extend to 2 years or fine or both. This is contrary. Means I am the complainant. If I would have filed false petition, this section 203 of IPC clearly saying they shall be punished with imprisonment. Means I would have been punished. The Honorable First Additional Sessions Judge neither punished accused nor punished appellant. This is intentional or unintentional or with any favor. How this provision of law is admitted by the Honorable Justice Lal Singh Srinivas Nayak ji. Now, para 9E. It is pertinent to note here that the dismissal of the complaint under section 203 of CRPC does not automatically result in the acquittal of the accused. Just now we seen para 9D, it was dismissed under section 203 of IPC. How this was delivered by the Honorable Judge Sri Lal Singh Srinivas Nayak ji. He may be knowing very well. In any case, there will be two parties, petitioner or respondent, complainant or accused. Any one must be guilty. Here, neither accused convicted nor complainant punished for giving false information under section 203 of IPC. So, the fun is going in the court of law. I am sorry to say, I am very sorry to say this. Here, the Honorable Judge Justice Sri Lal Singh Srinivas Nayak ji has not applied his judicial mind while delivering the judgment. It is a big contempt by our Honorable Judge. Honorable Judge says, a fresh complaint can be entertained on the same facts but only in the exceptional circumstances, such as when new facts arise, same could not have been brought on record in the previous proceedings and same is observed by the Honorable Apex Court in the Kaki Dhumakotia versus Bijendra Kumar Singh. Further, the dismissal of the complaint under section 203 of CRPC is not a rejection of an application under section 156 subsection 3 of CRPC. This is very good. I welcome this. But my prayer for this investigation under section 156 subsection 3 of CRPC was also not considered by Honorable Judge Sri Lal Singh Srinivas Nayak ji. Simply confirmed the trial court order. Neither investigated under section 156 subsection 3 of CRPC nor initiated process under section 204 of CRPC. This is very unfortunate. Not exercising the powers empowered with. This is a willful act of the Honorable Judge, I can say. Para 9F. On careful perusal of entire material record, this court arrived at a firm conclusion that the trial court properly appreciated the material facts on proper and perspective manner and dismissed the complaint under section 230 of CRPC. Honorable Judge is somewhere saying 203 of IPC, somewhere saying 230 of CRPC, somewhere saying 203 of CRPC. So under how many sections a complaint or a appeal will be dismissed? It is, who can say? To whom we can say? Because they are sitting in the legal chair, that is court of law. They have to be more cautious. They are bound to apply the judicial mind. Now we will see what the section 230 of CRPC says. Date for prosecution evidence. If the accused refuses to plead or does not plead or claims to be tried or is not convicted under section 229, judge shall fix a date for the examination of witnesses and may on the application of prosecution issue any process for compelling the attendance of any witnesses or the production of any document or other thing. Under this section, how the complaint was dismissed, the Honorable Judge Justice Lal Singh Srinivas Nayak Singh ji has to tell. I am a complainant and this provision of law 230 of CRPC saying if the accused refuses to plead, I am not an accused, I am an appellant. What do you say? This is not a flaw? This is not a lacuna? This section 230 of CRPC is also not mentioned in trial court's order. These are the judgments of our Honorable Judge Sri Lal Singh Srinivas Nayak ji. Further, that para, therefore, there are no sufficient grounds to interfere with the order passed by the trial court in CFR number 274 of 2023. Hence, the point is accordingly answered. And para 10, this is the conclusion para. In the result, the criminal appeal preferred by the appellant de facto complainant against the order in CFR number 274 of 2023 on the file of the Judicial Magistrate for First Class Banswada is hereby dismissed by confirming the orders of the Judicial First Class Magistrate, Banswara. So, till now, we have seen that the Honorable Judge Sri Lal Singh Srinivas Nayak ji has dismissed my complaint under 203 of CRPC, 203 of IPC, 230 of CRPC, and moreover, this Honorable Judge set accused ex parte in criminal offences, which is a gross violation of Code of Criminal Procedures. Observing all these irregularities and willful acts of the Honorable Judges Sri K. Sudhakar and Honorable Judge Sri Lal Singh Srinivas Nayak ji, I made a complaint to the Honorable High Court for the State of Telangana, Vigilance Department, and to the Honorable Chief Justice for the State of Telangana to take disciplinary action against these judges. But Honorable High Court for the State of Telangana is saying that the allegations leveled against officers are not willful act and misconduct. How Honorable High Court is saying whether are they really applying their judicial mind or not? I am sure they have the capability and they have the judicial mind because they were fully trained in the judicial academy. Then only they will be allowed to perform the judge duties, otherwise not. Section 203 of IPC and Section 230 of CRPC, is it a provision of section to dismiss the complaint? This is the judicial mind working in our state. It's a shame. I am sorry to say, very sorry to say, it is a shameful to the judiciary. Therefore, I request Honorable High Court for the State of Telangana to kindly look into my rejoinder and constitute a inquiry committee and take appropriate action against these unfair, partial, biased judges with doubtful integrity, so that the faith in the courts, judiciary and judges will be upheld. Otherwise, you are teaching the society to initiate or do or commit unlawful acts. Therefore, I request Honorable High Court for the State of Telangana to kindly constitute a committee and inquire the facts of my rejoinder and dismiss these judicial officers from the services. Thank you. Like all, I will not appeal for your subscription or your ringing the bell because my videos are not made for commercial or to earn money. The only intention and objective is to make public aware. Once again, thankful to you. Satyameva Jayate. Jai Hind.